6. We're hearing a petition for writ of habeas corpus. I did bring us into a Zoom hearing with the hopes that maybe we could come to some agreement without having to bring this 4-year-old child into court. If we can't, then we will do that, but it does seem hard on the child. So, Mr. Frazier, I believe this is your motion. Please proceed.
Yes, Your Honor, that's
Be
correct.
very, very specific on what you're looking for and what the concern is, okay?
Sure, absolutely, Your Honor. That we've got a child before the court, as the court acknowledged, a 4-year-old Inca. She's the only child of the parties and the subject of the pending suit affecting the parent-child relationship in Travis County. There are operative orders in place, those being temporary orders from a hearing on April 4th of 2022. That was a Zoom hearing in front of Associate Judge Arth. The parties went back and forth with some draft versions of those temporary orders. We ultimately had to have a motion to enter hearing in front of Judge Arth. The judge signed the operative temporary orders on that date. And so, of course, what we're here for, Judge, are the 4 corners of the controlling document. We believe there's a valid subsisting order governing possession and access of the child. My client is entitled to present possession of the child, and therefore respondent is illegally restraining the child. The question really seems to be about extended summer possession. And what is unique about these orders, these temporary orders, again, considering how young the child was at the time they were rendered, they do not afford Mr. Bloomling any extended summer possession. He has something called a temporary possession order. That term is used on page 6, and there's various different phases that Mr. Bloomling has graduated to.
I saw those 3 phases in there, yeah.
And he's currently under phase 3 because that began on August 15th of 2022. And that starts on page 7 of the temporary orders. And though he is awarded the terminology of expanded standard possession order is utilized, it's my belief that Mr. Bloomling is interpreting that gives him 30 days in the summer. But again, in the 4 corners of the document, he is not awarded any extended summer possession. And for the court's knowledge, even at the motion to enter hearing, there's not a transcript, unfortunately, from the hearing, but it was Mr. Bloomling, then represented by counsel's position, that 30 days should have been added. And so there were drafts that were done, and Judge Arth heard the argument of counsel and rendered explicitly in the operative temporary orders that he was not to have extended summer possession. If the court wants to indulge, there's many communications that led up to this weekend informing Mr. Bloomling that he did not have extended summer possession in somewhat sarcastic.
No, we don't need to get into the middle of all that. Here's our situation, Mr. Blooming. I have looked at this document. Let me hear from you. What's your situation? Why are we here today? Because I'm trying to do this as painlessly as possible right now, but it's going to, the pain meter is going to go up as we continue down this road this week. So let's talk about, I'm bringing you all in here today because you've got a 4-year-old child, and that child's best interest is always what directs me. Yes, so I don't really think it's in his best interest for me to have him come here on Wednesday, or on the alternative, to have a deputy come get him on Thursday. So where are we with this, Mr. Blooming?
Your Honor, the orders do clearly state that unless explicitly stated otherwise, I am to follow the extended standard possession order. I don't need to tell you the extended standard possession order. I get the non-custodial parent gets the child in the month of July. I notified Ms. Hudnall on March 30th of my intentions. She has repeatedly restricted to me, and I have this all very well documented, that she will not let me see the child for a minute longer than she is legally entitled to do so. I'm a teacher. I have the summers off. She is keeping our child from me at every opportunity that she gets. The document clearly states, unless explicitly stated otherwise, there is nothing in this document, regardless of how poorly it is written, that states anything about the summer. Because there's nothing explicitly stating the summer possession, then I am entitled to the ESPO. And the last thing that I'll say about this is that when this was written, the phase 2 going into last summer would have been July, which is why there was no expanded standard possession order then. And I completely understand that. I have offered Ms. Hudnall a very generous schedule for the month of July so that we can go visit our daughter's grandparents in Florida. She has repeatedly kept our daughter from me at every turn. I get no updates. I get no photos. I do not get invited to dance recitals. It is not in the best child's interest. Ms. Hudnall is working in her best interest.
Okay.
I have been pre-K.
All right, I hear you. Okay, Mr. Frazier, tell me where we are with this. What's the specific phrase in this document makes you believe that your client's entitled to have this child back this summer?
Sure, Judge, that Mr. Bloomling has specific periods of possession, the first, third, and fifth weekends of the month during the school term. There's no extended summer possession. And on the bottom of page 9, top of page 10, there's possession, the language says possession by Jessica Hudnall, my client. And it says Jessica Lee Hudnall shall have the right of possession of the child at all other times, not specifically designated in this possession order for Corey F. Bloomling. Mr. Bloomling is citing via this reference to the expanded standard possession order and online research extended summer possession that is not contained in the four corners of this document.
I'm sorry, I completely disagree. It says it in the very beginning of phase 3, preceding what you're citing. It says, unless explicitly stated otherwise, I am entitled to the extended possession. Your Honor, I will gladly do what you believe is in the best interest of our child. I have a very hard time believing that restricting access to both parents to a 4-year-old is in the best interest of the child. She deserves to have a healthy bond between both parents. I have followed the temporary orders to a T. I am up to date on child support plus arrearages that Ms. Hudnall is taking from me. This is not in the best interest of our daughter.
Okay. All right. So here's the situation. I'm not here to make a best interest finding today. The only thing I'm trying to do is follow the order as it's written, and the order indicates that she gets your child to be with her today. So here's the only thing I can do at this point, y'all. And it's not, I know, Mr. Blooming, I hear you, and I hear the frustration in your voice, and I hear that you do care very deeply for your child. The only thing is that I'm just looking at the order as it's written, not kind of attacking the order outside of its four corners. So the child does need to go to your wife today. Now, if that cannot be accomplished, then we got to come back on Wednesday and with your child here in court. And if he's not here on Wednesday, we got to send the deputy on Thursday. This is a 4-year-old child. So I think we need to go on and put our differences aside right now and comply with the four corners of that document, even if we don't agree with it. Okay, Mr. Blooming, can you do that?
Just so I hear you correctly, the explicit standard possession order does not apply to this situation.
Listen, you just have to follow the four corners of that document and look at it. There's the bottom of page 9 is where it's instructive. So here's what you
that's not in phase 3. We're in phase 3.
Okay, here's what you can do if you're not happy with it. And I've read the order. I do think that it appears to me from the plain language of that order that your wife has a child today. You can, if you want to attack some of that order, when you set up your final hearing, that would be your chance to have your attorney look at that. But today is not the day for that. I just have to go what's in that four corners of that document. And I have looked at it. And I do believe that Ms. Hudnall is correct in this. So, all right, so here's what I'm going to suggest, Mr. Frazier, Mr. Blooming, Ms. Hudnall. The child does need to go back to mom today. If that does not occur, then we need to set a hearing on Wednesday, and the child will need to come to the courthouse. If that does not occur, then we're going to have the deputies come out and pick up the child on Thursday. But right now, that's where we are right now. And
I'll drive her over to her house right now. Your Honor.
Right, very good. Thank you for that, sir. I appreciate that very much. That's obviously, it's critical that that occur, and it shows your care and concern for the child that you are willing to do that. And I'm very, very grateful for you doing that. All right, you all, I know this is not a terrific situation we find ourselves in this July 3rd, but it's the best we can do right now. When you do have your final hearing on this, there'll be an opportunity, I think, to question some of that order. But right now, we have to go with what's written. All right, Mr. Blooming, please get the child over there right now. Okay.
And my client's at my office, so she'll leave immediately. So should we say noon? Does that sound okay, Ms. Hudnall? Can you confirm? Is that okay?
It's 11:15. Yes, noon.
Your Honor. If there's going to be just a little bit of a lag time, my daughter and I made cupcakes this morning and we haven't put the icing on. So can we make it 12:15, 12:30, and then I can send her back with icing on her cupcakes?
Yes, Your Honor, that'll be fine.
All right, let's do that. Okay, with cupcakes and icing at 12:30. Okay.
12:30, Judge. And do you need? I'd like to probably have an order, or do you think an order needs to be circulated, Your Honor, for the file?
I think it probably does for the file.
Yes. I
but
can draft and send a copy to Mr. Bloomling for his review, and if we need some kind of entry hearing, which I'm sure won't be necessary, we could get with your court.
that sounds fine. Ms. Hudnall? All right, very good.
think
All
that's-
right, Mr. Frazier, Mr. Blooming, Ms. Hudnall. All right, I expect the
Oh,
child.
I'm sorry. Last second. I just want to make it clear. I am dropping our child off at Miss Hudnall's residence. Is that correct?
That's
understanding
correct.
at
At
12:30.
12, by
12:30.
12:30 today. So that gives you a little over an
Good.
hour to get there. Okay?
Thank you very
Thank
much.
you, Judge. Thank
All
you
right.
so much.
You all have a great rest of the day.
Thank you,
Happy
Your
New
Honor.
Year.
Good luck with everything. We're here on a petition for writ of habeas corpus and attachment. Ultimately, what this writ would allow a deputy to come to the house and take the child back to the other parent, or on the alternative, to have a hearing down here at the courthouse where everyone comes in person and brings the child, and then the child stays with one parent, not the other one. In an effort to avoid those two outcomes, because I personally think they're quite hard on children when deputy comes to get them and they're brought down to a courthouse. We're having a little Zoom hearing this morning to see if we could have a conversation that precedes that and precludes those. I mean, I don't know. I wouldn't like the deputy come out to my house, or wouldn't like to bring my child down to court. And those are the next steps. So here we are. Ms. Braun, this is your motion. If you could
Yes.
please, in pretty short order, show us, and we're not here to change any orders. So we're not here to take evidence. We're here just to talk about the four corners of what's written and where the child is now. So please proceed, Ms. Braun.
Yes, Your Honor. So it's a simple matter. We, pursuant to this order, this is a certified copy of the order that I'm sharing with the court and all parties right now. Without written notice by April 1st, my client is to receive a child from June 15 at 6 p.m. and ending at July 2017, the same year. My client did not provide that written notice. In fact, he confirmed via text message that I will be picking up our son on June 15th. Here is the plane ticket, to which he was blatantly denied by respondent, saying he's not available, you can't have him, and what have you. So we filed this to get some relief. They are residing in Travis County. Per chapter 157, this was the avenue that we decided to pursue in order to get rightful possession of his son.
Right. Okay. All right. Very good. So the portion you're talking about there is you've screen shared with us, and it says, without written notice by April 1st, if Sahari Nazaranka does not give Alicia Redina written notice by April 1st of the year, specifying an extended period or periods of summer possession for that year, Sahari Nazaranka shall have possession of the child for 42 consecutive days, beginning at 6 p.m. on June 15th and ending at 6 p.m. on July 27th of that year. Is that correct?
That's correct, Your Honor.
All right. So, Ms. Redina, tell me the situation here, because it looks pretty straightforward to me.
Yes, I completely agree, Your Honor. So I do want to mention a couple of things. First of all, we do not live in Travis County. We live in Williamson County. I also was not notified about this court date ever. I just received Mr. Nazaranka contacted our 17-year-old and put him in the middle of this and notified him and sent him a link to the Zoom. Otherwise, I wasn't even, I had no clue this was happening.
Yeah.
Also, Mr. Nazaranka never purchased tickets. He never attempted to pick up Kirill on the 15th. So on the 18th, he told him to pack up his things. And I said, well, you were supposed to pick him up on the 15th. So we thought you changed your mind and you decided not to do that. And that was the extent of it. Then I received a very threatening letter, email from the lawyer, and I never heard anything else. And also, I did not have time to hire a lawyer or any kind of representation for myself, which I really feel uncomfortable being even in this courtroom and representing myself right now.
Well, you're doing fine. Here's the situation. It's a hearing that can typically happen without both parties being here. The only reason you're here is because my staff and I wanted you here because we didn't want to have the deputies come to your house after I ruled on the writ of habeas corpus. That's the only reason you're here. But something else you said causes me a little bit more of a concern. The information we have, you're living in Travis County. When did you move to Williamson County?
We never lived in Travis County. We always lived at the same address in Williamson County. So I don't even understand, why we being in the Travis County court.
May I?
Yes, you may.
I'm not sure if Ms. Regina is aware of her duty to file a notice of address change with the court. We don't have anything like that. We were under the impression that they lived in Travis County. We were provided an address to Travis County. That's why we filed. This is where the child was residing. For Chapter 157, this is why we filed.
I never resided in Travis County. So what is the address it was even filed under?
I'd have to look.
What's the address that you have on file for me? Because I never resided in Travis County. I always, since I moved to this area 5 years ago, I always resided in the same address, and it's Williamson County.
Okay. So here's the situation. This court, if it's in Williamson County, it's not something we can take care of. That'll be the Williamson County Court. I will say this, if you all refile in Williamson County, the judge is not going to have any additional choices that I don't have right now. I mean, it's going to be the same thing, Ms. Redina. So it's up to you, but you might want to try to, rather than have to show up at a court hearing again. Also, with the threat of a habeas corpus hanging over your head, you might just want to go on and comply with that agreement. And I know your child is 17. He or she is getting, they're almost aged out, but go on and get this summer possession issue taken care of rather than having to go to court. I don't have any jurisdiction over this though, if they don't reside in Travis County. Okay. All right. So you all please try to get this taken care of without going to the Williamson County courts. But if you can't, that's your next stop. Okay.
Okay, sounds good. Thank you.
Understood. Thank you, Your Honor.
At all defendants. We are here on a motion for default judgment. Mr. Diaz, would you please make your announcement?
Yes, Your Honor, may it please the court. This is Tony Diaz. I represent the plaintiffs Jesus M. Herrera and Maria D. Herrera.
All right. Okay, Mr. Diaz, it looked to me like you were here on a motion for default judgment. I will say that we took a minute to look at TCAT, and it looked to us like your client maybe already owned this home. Was there a change? Looks like he somehow or another acquired it.
Well, they bought this home from the original owner and they made payments based on this agreement that they had. And the owner had told them that he was going to pay the taxes, the insurance, and so on.
Sure.
Of course, he raised those fees and they continued paying. They paid for 30 years.
Yeah.
And then when it came time to transfer the title, it turned out he could not. There were liens. I had to sue basically Chase and a bunch of other people because they were in foreclosure proceedings.
Mm-hmm.
And what they did was they retained me. Then I was able to talk to these folks, and after quite a bit of convincing, they went ahead and paid the debt that the original owner did not pay.
Okay.
And that's how we were able to transfer the title, but the damages remained.
Okay.
And so basically that's what they're asking for.
All right. So let me look here at this order that you sent to me. Okay. So you're looking for unliquidated damages in the amount of $225,000. What were those for?
Wow, they had to pay like $75,000 to get the title back into where the people would drop the liens. In other words, he had not paid any taxes, and then he took a note and refied it to be able to pay those taxes. But then he didn't pay the note, and they foreclosed on him. So part of that, most of that was to pay to get the title cleared.
Sure. So he owned, but your client owns that home at this point, right?
Yes, he does. I got all that straightened out. Thank God. It was a fight.
Is there any, I mean, it's just to sign a judgment for $225,000. Did you attach any of these? Let me look here. I mean, I just didn't know. May I'll look again, and I'm not trying to be difficult. I just looking to see. Let me look at your default judgment and read it here real quick. Kind of look through it and hang on, see what's attached. I saw there were some attorney's fees requests in there and some other things. Looking to see what you attached to it. Let's see here. I see the military status declaration that you have in there. All right, so here's the affidavit from Mr. Herrera. In that, does he, I'm trying to move it over a little bit so I can see it better. Did he designate his expenses in this, or?
I think let me look at it real quick, Judge Sarkin. I think he mentioned what he had to do.
Mm-hmm.
He talks about the taxes that he had to pay. Basically, he had to bring up the taxes. He had to bring up the insurance. He had to then pay the cost.
Okay, here it is. As a direct and proximate result of Solis's action, we've been injured as follows: suffered mental anguish from threats and misrepresentations, had our property rights interfered with, and paid approximately $225,000 to defendant. So that's to defendant. Did you pay that to defendant, or did you pay
Well,
it?
there were other defendants. In other words, we had to sue a bunch of people to be able to get him back where he was.
Yeah. Yeah. I just don't know that we're quite here yet with what you've got. The reason for that is that I get the mental anguish. I totally understand, but $225,000 in unliquidated damages. And then he paid over the course of, I think what he's saying there is that he paid over the course of the 30-year note. He paid what he was supposed to pay. And then on top of that, this guy kept adding more and more and more, and he paid all that too. Yeah.
And after the 30 years he paid it all, the guy did not have the title because he had taken a loan out to pay these very damages. And then he kept that money himself and didn't pay these damages. So the title wouldn't transfer.
Yeah. But thankfully now it has transferred. That's good.
Yes.
Right? So
yes.
no, that's good. So here's, I guess, a couple of things I'm looking for. I see you've asked for your attorney's fees in an unsworn declaration. This is not meeting the standards that we have under the Rormus case.
Yeah, I just noticed that.
And that's so that's an issue. And also in your affidavit, you really are going to have him spell out what was paid for what was paid for purchase of the home, and what was related to these other categories. It's got. I just can't. I can't grant you relief based on what I have. It's just not quite specific enough on either the home itself or on your attorney's fees. So here's what I'm going to do. I don't want to put you in a spot with this. So I'm going to deny it, but without prejudice. So you can come back later, but he needs to, rather than just say, I have all these damages, really provide information. I paid this amount. If he can provide a receipt, that's going to be even better. You know what I'm saying? Because I'm mental anguish for this. I don't know about that so much, but if he really did have to pay taxes and things like that so that he could get that clear title, just any receipt that he has and then attach it to that affidavit, that would be, and state in there that that it's a true and correct copy, or get a custodian's affidavit on it. That would sure help me. I just can't, Mr. Diaz, it's no offense to you or your client, but this evidence you provided is just not quite specific enough. You know what I'm saying?
Yeah, that's fine.
Yeah, and I don't want to put you in a really bad spot with this. So like I said, I'm going to deny it, but without prejudice. In other words, there's no harm, no foul.
I think what I might do is just have it sent and then bring them and let the judge talk to them, and then see, they're not very sophisticated people. That's how they ended up in this problem.
Yeah.
And actually, I wanted to help them because it kind of broke my heart. I'm getting old, and I'm trying not to do these things anymore. But sometimes, And so what ended up happening is they basically got duped by this guy. So I think if they testify, I'll tell them to bring the items that the court's instructed. And I think if we have a live hearing, then the judge could talk to them and ask them whatever particular questions they have.
I think that's a good idea too. Just make sure that they bring the documents with them, and better yet, if they can get a records custodian. You know, I don't know who they paid it to, but TCAT or whoever they paid this money to, that says, you
They
know.
paid it to him. That's the
to the
problem.
guy. Okay.
They paid it to him. He was telling him, I'm paying all this, and he was never paying it. Then he took a mortgage on the house, and then he said he took that mortgage to be able to pay the taxes, and then he took the money from that mortgage and did not pay. And so at the end of the day, Chase Bank and everybody came in trying to take the property, foreclose, and that's when they hired me.
Yeah, but it doesn't look like it didn't. I didn't see a TRO, so I guess Chase Bank has backed off now that they own it, right?
No, well, we had to pay Chase the money that he owed. In other words, that's what he's saying here in this affidavit. We had to pay the money that Chase said that was still outstanding to them. And then they paid that money to Chase. And then I was able to get Chase the non-suit and drop their claims.
That's
and
good.
so the only remaining defendant is Solis,
Mhm.
and he doesn't want to participate. He doesn't want to answer, basically.
Yeah. Well, here's my thought. You know, just go on and have them really spell out in an affidavit, even if that just, it'll just be a good exercise for them. In other words, it'll make them focus before they get to court, what they agreed to pay for the home, and kind of say that this is what we agreed, and then this is what we had to pay in taxes, so that whoever looks at it and any documents they have to support that. So, because it could come back to me, it may not, I don't know. But so that the judge can really get their hands on it.
I got it. That makes a lot of sense.
Yeah, on your attorney's fees, take it. It's called the Rormus case. It's spelled like RAROARMUS or something like that. It'll tell you how to do attorney. Yeah, here it is. It's ROHRMOOS. Looks like Rormus. ROHRMOOS. And that'll show you how to what the court's expecting on your attorney's fees now. And I think that those two things, if you really, get them to sit down and say, okay, what did you pay for the house? All right, spell that all out. Okay, then what did you have to pay in taxes? When did you pay it? Who'd you pay it to? Get that all together, and then get your affidavit on there and come back up for a hearing with any documents that prove it. I don't think you'll have any problem. I just think today we aren't quite there.
Okay, Judge. I'll get that done as soon as I can.
All right, it's a pleasure to see you today, sir. Have a wonderful
Pleasure seeing you.
Yes,
Happy
I
4th.
know
God
he's
bless you
on
all.
here.
Thank you.
And
Thank you.
then a question.
Can anyone hear me?
Yes,
Yes,
we
Mr.
sure
Royal.
can. Thank you, Mr. Royal, and we can.
Okay, I'm sorry. I know I had asked 5-10 times and no one answered, so I'm sorry about that. But I'm in here now, so my apologies.
That's no problem. Mr. Gregory Royal is the plaintiff here. Could I please have an announcement from Mr. Royal and then from defendants?
I'm Gregory Royal. I'm here today. Is that what you're asking me, Your Honor?
Yes. Okay.
Jennifer Grosswith on behalf of Apartment Management Professionals.
All right. Thank you, Mr. Fountain. Who are you with today, sir?
I'm here representing the Baltimore area and his company, landscaping company.
Landscaping company. Okay. Mr. Royal, I believe that you had asked for us to reconsider some rulings of the court. And so take a few minutes and tell us about that, okay?
Thank you, Your Honor. Thank you for having me, and thank you for agreeing to hear. In short, Your Honor, in addition to what I've written in my motion for reconsideration, as I appreciate the Texas law, I've raised a genuine issue of material controversy as to whether Baltimore Arias and MB Landscape Solutions is an actual employee of AMP Properties, or Apartment Management Properties. I'll just say AMP, as well as Bridge at Terracina LLC, doing business as Bridge at Terracina Apartments. And I raised the issue that on June 2nd, when I was injured, when Baltimore Arias's employee, land care agent, injured my eye, caused injuries to my eye, and I went to Bridge at Terracina Apartments to report that their employee had injured my eye. They did not deny that that he was their employee. And when Baltimore Arias's employee also went to Bridge at Terracina to allegedly report somehow I attacked him. He went there with the intents that they had control over him. When I spoke to Joni Frieden was at that time the regional property manager. Joni Frieden assured me during a telephone conversation, I've submitted emails to that where she said, would you like to talk during a telephone conversation, that that employee would no longer work on that property at Bridge at Terracina. I would not see him. And I have a witness that when I was speaking to Joni Frieden, Tracy White, she sat in conference listening to the telephone call where she promised me that. I had Joni Frieden on speakerphone. 2 weeks later, it was Tracy White who said, hey, that guy's back on there. She lied to you. And then I also, I think those emails and the things submitted or should have included the fact that I told Joni Frieden, the property manager, that she said that he would not be there and he's working there. That prompted us to take pictures on in July when we saw him, July 14th, I recall, that same guy being on the property, because that at that time, that's July 14th, 2020, I'm reporting back to Joni Frieden works for AMP. Let me state that for the record. She's their employee, but also the regional property manager. AMP, as I understand it, owns several units within the Bridge at Terracina apartments, even though the city of Austin is the primary owner, as represented by AMP during the eviction hearing, they own several units. Now, Joni Frieden was the regional manager. If at that time, Your Honor, I asked if the court stays with the motions, affirms its own motion, then at the time I've been defrauded by Joni Frieden. They engaged in fraud to mislead me to think that they actually exercised actual authority over their lawn care employee. And if not even actual authority, they had, to me, Joni Frieden, Brooke Shields, Brooke Wright, sorry, not Brooke Shields, Brooke Wright, the local property manager, had apparent authority. And when they say they don't have any sort of control over them, I give an example, an argument by example. Let's say this lawn care guy, as I charge him to do, when he sees white tenants, when he sees Spanish tenants, and I've watched this as well as my witness, he stops using that weed whacker. But when it's black, when it was me, a black tenant, he even testified in his documents to the insurance company that he was 4 to 5 feet away from me and he still used this weed whacker. So that's intentional. Now, if they don't have any sort of control, as Ms. Grosswick wants to say, I've been defrauded on that day, then also they're negligent in the fact, I would like to amend my complaint, to be opportunity to amend my complaint in this proceeding, because if I'm not allowed to do it in this proceeding, I may be barred from doing it, but there was no way I could have known that they didn't exercise some degree of control. My argument is this: if their lawn care company was going around with a slingshot, for example, shooting black tenants, pow, 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 and they knew about this, but they don't exercise it in control, then apartment management has a duty. They like to point to the TAA contract that tenants sign. I would have to safely say 95% of all rental companies use that same TAA thing. Some of those terms in there are unconstitutional in the sense that, for one, they say they have no duty to the tenants to provide them security. Well, my research of Texas law says that statutes that they do have a duty to provide the tenants some degree of security. So that provision in that contract would likewise be likely, if challenged in a court of law, stricken because it violates Texas law. As my responsibility as a plaintiff, bringing my argument to close, I raised the issue, the genuine issue of material controversy as I can, that they controlled it. Jennifer Grosswick stood before you on May 1st and just simply argued conclusory statements when she knows she controls the contract agreement between AMP and MB Landscape Solutions. She controls that contract agreement. I asked the court, and I didn't know whether I could do it beforehand, and I did not want to come across, Your Honor, as being disrespectful to the court and to the court's order. So I didn't go ahead and serve a subpoena ducis tecum on AMP properties because the court had already ruled that they, in some that they were dismissed. So I asked that I be given just that opportunity to serve a subpoena ducis tecum on AMP properties to come forward with the legal agreement between AMP properties and MB Landscape Solutions. And that would solve all of this as to whether they are an agent, an employee, or independent third-party contractor, which AMP does not exercise any control over. But I've already raised the issue that they do, and I've submitted some documents that they do. In fact, Your Honor, in those emails, Jenny, after Baltimore IRS's employee in his to try to get out of the fact that he injured my eye, he went and told them that I attacked him. Now, I physically attacked him and assaulted him. They did not call the police on that day. Mr. Fountain has gone forward and said that it wasn't even his employee, and that's in the 93 pages worth of deposition on January 31st. Mr. Fountain repeatedly argues that the employee, that the individual that injured my eye was not an employee of Baltimore IRS or MB Landscaping. However, today, Mr. Fountain has served as Rule 26 disclosures, where now the same individual who injured my eye says that he is an employee of MB Landscaping, and he was the employee using a weed whacker on that day.
All right, Mr. Royal, I hear you. We've given you some time now to present your case, and I would like to hear now from Ms. Grosswith and then from Mr. Fountain. Ms. Grosswith.
Thank you, Your Honor. Jennifer Grosswith on behalf of Department Management Professionals. We issued a timely, proper challenge to Mr. Royal under the Texas Rules of Civil Procedure regarding traditional and no evidence motions for summary judgment. Mr. Royal has failed to rise to that challenge. He failed to rise to the challenge on May 1st at the summary judgment hearing, and he fails to do so today. Plaintiff's only claim against AMP was for responding at superior as to MB Landscaping's negligence in causing debris to become lodged in his eye during the landscaping activities. And it is his burden, and his burden alone, to prove by a preponderance of the evidence the elements of his vicarious liability claim, which are: one, that the worker was an employee of AMP, and two, that he was acting in the course and scope of that employment. AMP moved for summary judgment on the basis that Texas law does not allow for vicarious liability of an independent contractor. Plaintiff had no evidence to meet the exceptions of the rule or the evidence to support the essential elements of his claim. The things that he's talking about today, that is still not competent summary judgment evidence, and his statements and recitations of events are hearsay and not authenticated admissible evidence. The court correctly granted AMP's motion for summary judgment. Plaintiff failed to timely respond to the motion. Thus, there was did we just lose someone?
I don't know. Maybe you lost Ms. Guardiola. She'll probably be back.
Okay.
But Mr. Royal is still here. I'm still here. Mr. Fountain is still here. So I think we're still okay.
Respectfully, Your Honor, it was a Mr. Dillon, who I don't know who it is. I keep seeing his name. I haven't received any communications from him identifying himself, but he's the host now.
Yeah, he's the team staff attorney. It's okay. It's
okay.
Right. We're a team. You just think of me as the judge, but I'm just one member of the team. So he's another member of the team that comprises the court. But thank you, Mr. Royal. All right, Ms. Grosswith, let me hear for a minute from Mr. Fountain then.
Your Honor, this involves a motion for summary judgment that was directed by the co-defendant, the apartment complex, against the plaintiff. We did not file any responsive pleadings on that.
Okay. All right. Very good. Thank you, Mr. Fountain. Thank you, Ms. Grosswith. Mr. Royal, anything in closing your arguments today?
Yes. Quickly, Your Honor, I believe I believe that not only Ms. Grosswith argued just now that I only asserted a claim under vicarious responsibility. That's not correct. I did it under respondeat superior, as well as an agency theory. And as I've researched since, under agency theory, there are exceptions. And under the agency theory, there are exceptions. And discovery at the time she moved, Your Honor, discovery is not closed because to my knowledge, we have not set any trial date to begin a calendar where I would have so many days, as I understand Texas law, to complete discovery before a trial was set. To my knowledge, no trial has been set. So discovery was still there. And I would have opportunity to even serve requests to produce documents, requests to admit, and interrogatories, which I was not allowed to done because I'm sorry, I'm anxious at this stuff, which I was not allowed to do because simply she rushed to file summary judgment. Without coming forward, Your Honor, I would state that it was Ms. Grosswood's because she knew she would raise this issue. When she received the complaint, she knew she would raise this issue. She was supposed to have given me a copy of the lease agreement, or not the lease agreement, a copy of the agreement between Baltimore Arias and the AMP in her Rule 26 discovery documents, which she failed to do. She concealed and she hid that, knowing that Rule 26 requires her to give me that evidence because it was in her possession at the time, and she was supposed to turn that over, which I did not receive. That's the injustice that's occurring to me. The second point I want to make is that I submitted a 93-page deposition that was taken from me on January 31st, 2023. I submitted all the complete deposition when Ms. Grosswick in her motion for summary judgment only submitted 8 pages. To conceal the fact that all that testimony I gave, that is admissible in the court of law. She keeps saying that it's not. I've already explained to the judge, even the statements, the emails that I submitted, and I'll cite it again because obviously Ms. Grosswick doesn't understand Federal Rules of Evidence 801 D2. That's admissible as a statement by a party opponent, and Federal Rule of Evidence 803-6. It's a business record. Every email, they keep my tenants thing. And I close with that, Your Honor, asking that I be given just limited discovery on AMP to submit a subpoena ducis tecum to obtain the lease agreement. Because this is what's going to happen, Your Honor. I'm going to submit my discovery requests before this holiday is over on MB Landscape Solutions, asking for that same agreement. If I find that same agreement, and it says that, and shows anywhere that AMP exercises a degree of control, then Ms. Grosswick has misrepresented herself and her client to the court. Then I'm going to file motions for sanctions and everything else, saying that she did, in fact, just do that. And we're going to have this big old mess that we have one already coming with between Thomas Fountain and I.
All right. So all right. Thank you for that, Mr. Royal. Thank you, Ms. Grosswood. Thank you, Mr. Fountain. Here's my thought. Ms. Grosswood had come forward with a summary judgment on the issue of independent contractor. And I will say the law in Texas regarding independent contractors is it's pretty straightforward and it's hard to get around. What she's saying is, look, this is an independent contractor out there. It was not my client doing that. She came forward on a summary judgment and presented competent arguments in that regard. So that's why I granted the summary judgment, and why I'm going to choose today to not revisit that issue or change that ruling. I think Ms. Grosswood provided strong arguments in that regard. That being said, Mr. Royal, certainly it's concerning to the court, and it would be, I would hope, to all caring citizens or all caring people in our community, if your impression is that we've got a landscaping team out there that's treating African Americans differently. I don't know if that's your perception, and you're certainly entitled to it. Nonetheless, what Ms. Grosswood had brought forward to us was on a different issue, and that was really on the issue of independent contractor. And so these arguments don't address that. She has adequately presented her arguments and represented her clients. She came back to my courtroom on a previous hearing that you weren't there, so we reset it today. She's come back again today and reasserted those arguments, and she's right in what she's presented. So although I appreciate very much you taking the opportunity for me to reconsider that earlier ruling, I'm not going to overturn it at this time. So the motion for summary judgment stands, and the court will not be granting any other relief today. All right, Mr. Royal, best of luck with you in the remainder of this lawsuit. Any relief you've requested today, as I said, is denied. Nonetheless, I do hear your concerns, and it's a grave concern to the court if your impression is that you've got a landscaping team treating you differently than other people at the complex there. All right, folks, with that.
We have another motion, Your Honor.
And what was the other motion, Mr.
The
Wolf?
motion for sanctions for the conduct of both the defendants during I have a motion for sanctions on the misconduct during a deposition. I find that unfair that my motions are not being heard. I've read extensive law on the conduct of attorneys.
Okay, I'm all right. Hey, back off just a little bit, okay? Your motion to reconsider summary judgment is denied. All right, so let me hear now on the sanctions.
Okay, Your Honor, may I object for appeal purposes just to preserve my arguments on a motion for summary
Make your
judgment?
objection. Make your objection. You object. The objection is overruled. Okay, please proceed.
On the motion for sanctions against the both defendants, Thomas Fountain and Mina Haderi, for their misconduct during their deposition on January 31st, 2023. If we're going to follow strict compliance to Texas rules, then Texas rules, especially Rule 199, requires that the defendants serve notice, proper and timely notice on me that they're going to depose me.
All right.
It does not require one defendant to serve a notice for his client and then all the other defendants. And certainly we have even more than just two defendants. Some of them have not been served, but by argument via analogy, I'll make this argument now and continue on why it's important. If there were 100 defendants in this proceeding and only Mr. Thomas Fountain had served me notice, which was proper, et cetera, that his client, Baltimore Arias and MB Landscaping, was to depose me on January 31st. The other 99 defendants couldn't show up also on January 31st. And then after Mr. Thomas had finished his deposition, demand that I sit through all 99 attorneys deposing me when they had not served proper notice. I cannot come forward with this court with this notice that Mina Haderi of Jennifer Grosswood's partner and Wilson Elser's attorney served on me, because there is none. However, during the deposition, Mr. Fountain engaged in his own independent misconduct. In depositions, the rules are very clear. The attorney taking a deposition cannot insert his ad hominem, cannot begin to argue with the opponent just because he doesn't agree. Throughout my deposition, and the attorney taking a deposition cannot repeatedly browbeat and harass the deponent with the same question. Throughout those 93 pages is evidence where Mr. Fountain, one, continuously asked me, because I didn't agree with him, whether the other land care guys told me what happened to my eye. Did anyone tell you what happened to your eye? I didn't need anyone to tell me what happened to my eye, because I was there when the Baltimore Arias employee injured my eye. Also, Mr. Thomas inserted his own arguments and answers to his own questions. He would say, well, I'm just going to take your answer as a no. He did that repeatedly throughout the deposition, causing me to argue with him that he can't put words in my mouth. I don't have the 99 pages in front of me, but I can tell you, Your Honor, I believe on page 70, if memory recalls me, page 70, lines 3 through 8, as memory serves me, Mr. Thomas Fountain said, well, I'm just going to take your answer as a no. And I argued with him that that's improper throughout. I may not be a litigator, but I do know for a fact you can't do that. He also, what he did was, when they go on, he's disrespectful and violating the rules, in that when I would make an answer, he would continue to argue with me that well, it wasn't even, if I would say yes, Baltimore IRS's employee, I don't know his name, I've asked you all to identify him, injured my eye, Mr. Thomas would then reply, instead of asking the next question, he wouldn't object or anything. He would just simply say, well, no, he didn't hit you. It wasn't even his employee. You don't know if that's who hit you. I say, I saw him do it. And this takes place throughout this deposition, which one, makes it extremely unnecessarily time consuming, wasting my time. And two, I would state from Mr. Fountain's conduct is Mr. Fountain was very much aware of that on January 31st. I was late to this deposition. I was late about 45 minutes, if I recall, because on January 31st, AMP had evicted me through the Travis County. So I went from an eviction, grabbing all my stuff and trying to secure it. And on January 31st, there was inclement weather. It was sleet, rain, and it was a storm. I'm sitting outside. Mr. Thomas and Miss Mina Hadiri were both told, I apologize, I'm late. I was just evicted by the Travis County constable. I'm sitting outside of well, I'm in a laundromat, but outside of an apartment, and I'm to the deposition. But with that knowledge, Mr. Fountain repeatedly engaged in attorney misconduct, harassing me with vexatious questions and then arguing with me. When I moved forward to the part of, again, on page 71, Mina Hadari brings up Rule 199, because I asked to see the rule that allowed her to just show up on the day of the deposition and start asking questions. Mr. Fountain even argued with me, and I think that took place for maybe 1 or 2 pages, about 199 allowed only him to send a deposition, but all other defendants to come in. And I used that same argument that day, the 100 attorneys, 100 defendants, and one only serving a deposition. On page 72 of the transcript, page 73 of the transcript, I think it's on page 73. On page 73, it's lines 3 to 25. Mina Hadiri and Thomas Fulters misrepresents that 199. Texas Rule 199 allows Mina Hadiri on behalf of AMP to appear without proper notice and assert arguments. So from page 75, it's lines, page 75, now I'm getting into this, page 75, lines 16 through 25. That's where Mina Hadiri of Wilson Elsa on AMP, she tries to argue with me that Rule 199 allows her just to show up only because Thomas Fountain had served notice of the deposition, and for her to ask me arguments. We went back and forth with that on that very stressful day, and I terminated it. I repeatedly said, let's go to the judge. On page 82, I think it's page 82 through page 90, somewhere in there, I said, let's just go to the judge on this, because I think you all are intentionally misrepresenting the Texas rules. Thomas Fulton has over at least 10 years of experience in Texas law. Mina Hadiri is a partner at a very prestigious large law firm, or an associate. They hired her. She works for a very big law firm in Dallas. If she's not a partner, she's competent enough to earn a job there, where many attorneys who are also competent and did very well in law school didn't. They both were very aware of the rules of Texas, the Texas rules of procedure, the local rules, as they call them, Rule 99, but they intentionally misrepresented it that day because they believed that I would not challenge them on it, and they refused to terminate the deposition.
Okay, Mr. Royal, let me ask you a couple of questions here. It sounds like, because we've got both Ms. Grosswith and Mr. Fountain on here, it sounds like although your motion was asserted against all defendants, it seems like it's Mr. Fountain he had the concern about. Is that correct?
Mr. Fountain and Miss Mina Hadiri, Your Honor.
Okay, let me hear them. Since we have Mr. Fountain here on this call, let me go on and hear from Mr. Fountain in response to your arguments. Mr. Fountain.
Thank you, Your Honor. The transcript has been attached as an exhibit to this motion. I think I don't remember who provided it, but I'll defer to it. It speaks for itself. The main issue that is being described by Mr. Royal is the fact that Miss Haderi showed up to today, ask questions at a deposition that I noticed and he agreed to.
Mhm.
I finished my questions. I passed the witness and she wanted to start her questions. And he says, no, you can't do that. You need to have sent your own notice of deposition. I didn't agree to that. You didn't send it.
Mhm.
So, I mean, that's really the crux of that particular argument. Of course, the rules of civil procedure don't mandate that. The Rule 199 executor just, I don't remember the exact wording, Your Honor, but it provides all parties to a case the opportunity to show up and ask questions when a deposition has been noticed. And that's the only thing that happened that day with respect to co-counsel or counsel for the co-defendant. The issue with respect to me harassing or asking inappropriate questions or repetitive questions, this is one of the most benign depositions I've ever taken, Your Honor, and I respectfully disagree with the characterization offered by Mr. Royal. There was no disrespect showed to him in my questioning, and there was absolutely no intent to, nor was there actually any inappropriate questioning provided to him. My intent was just to identify the basis of his allegations of liability and his damage model. And that's what I did.
All right, thank you very much. Ms. Grosswith, do you have anything to add to this?
I would just add, Your Honor, that I believe that 199.5 is the rule that addresses the notice of deposition that says the parties may examine and cross-examine the witness based on a notice of deposition. And to Mr. Royal's example of 100 defendants showing up on one notice and asking questions, I am routinely engaged in cases where there are multiple defendants and we all show up under one notice and ask the questions. It was not improper procedure for Ms. Haderi to engage in terms of trying to cross-examine the witness on a deposition notice that he appeared for. And didn't.
Right. Sorry, Ms. Grosswith, I didn't mean to interrupt. Please go ahead.
Thank you, Your Honor.
All right, thank you. Mr. Royal, do you have anything to say in closing?
Yes, Your Honor, I'll take them in reverse because Ms. Grosswork said Rule 99 states that all parties can be on a single deposition when they list all defendant parties on a single deposition. Often joint defendants sign agreements where they have a common interest. In this case, there is no joint agreement signed between Jennifer Groth, Wilson Elser, and Thomas Fulton. There is no common interest because they have no joint defense. Now, the notice of deposition that was sent to me by Thomas Fountain only listed Thomas Fountain. Ms. Grosswick and Mr. Fountain would be correct under Rule 199 if, in fact, the law firm of Wilson Elser, to say it short, it's a long one, was listed on the deposition itself, because only Thomas Fountain's law firm was listed on the deposition. Only Thomas Fountain served me notice. It has to be on the deposition, the notice of deposition sent to me, this long laundry list, and in this case, just two, where they gave me proper notice. I believe, and I don't have the rule, and I'm not going to pull it up, I'm just going to go, my memory, I believe, serves me that it's Rule 199.2 says that I have to receive reasonable notice, and that's from all the parties. I didn't receive reasonable notice from Ms. Grosswick. Now, moving to Thomas Fountain, Mr. Fountain did more than that, and the evidence is shown in the deposition transcript, and I pointed out in there, Mr. Thomas and Ms. Mina Haderi, they're both arguing that and intentionally misrepresenting Rule 199. They're now trying to try to play ignorant to the rule, why both of them, and this is where the Texas disciplinary rules of professional misconduct come into play. Rule 8.4 misconduct, which says a lawyer shall not engage in fraud, misrepresentations, deceit, or dishonesty. Rule 8.4. Now, what they're doing is they're abusing this court. This is a Texas court. They're Texas attorneys. I'm not. Texas attorney, they're abusing and trying to gain bias. Mr. Fountain's conduct, Your Honor, has been, he has engaged in attorney misconduct 4 times. Another time before you, he defrauded you on May 1st when the court came to court. The court, you, Your Honor, respectfully, you, Your Honor, you understood that there were only 2 motions, and they were both filed by Jennifer Grosswick. One motion was a motion for summary judgment, and it was in the alternative, a motion for to compel. Now, when you granted the motion for summary judgment, that made moot the motion to compel. And the court, you, Your Honor, respectfully said, okay, that concludes for the day. But Mr. Thomas, knowing that he had not filed what they call that notice ready agreement, that form, when he had not filed that, he says, Your Honor, we have our motion today. And Your Honor, I could not object to it because you had already told me to sit down and be silent. But Mr. Fountain defrauded you. He knew that he had not, as well as, and I have other, so Mr. Fountain did more than just ask questions. I'm pretty certain of it. My memory is that good. I'm pretty certain of it. I was tested as a child for this on page 70, lines 3 through 8. Mr. Fountain does more than just ask questions. He says, I'm just going to take it that you say no. I read extensive law, a case judge's opinion. One federal judge out of DC wrote specifically about attorney misconduct. Also out of the Seventh Circuit, these judges took to write themselves on attorney misconduct.
All right, Mr. Royal, we need to, I hear what you're saying. And it sounds to me like this deposition occurred on a day for you that was really, truly terrible. If you had just been evicted and then you had to go to a deposition, that sounds like a deposition on a good day is not a great experience. A deposition when you've just been evicted must be a terrible experience. Plus being stuck out in stormy, cold weather, trying to conduct business from a laundromat. My heart goes out to you. I really can't even imagine the frustration you felt that day. That being said, from what I can see from Mr. Fountain's behavior and Ms. Grosswood's behavior, I don't see that either one of them did anything wrong. I will say that sometimes I've seen those notices go out. You'll get cross notices going, but more often than not, they're just as what happened with you here. There was a notice that went out and somebody else asked you some questions at that. So I'm not gonna grant relief on that. Also, I did review Mr. Fountain's actions back in the court. I've got no indication he tried to defraud this court. So I'm going to deny that relief. You all vote. So the motion for sanctions is denied. That concludes this hearing for the day. And you all may be excused at this point.
May I object for appeal purposes?
You may object, and your objection is overruled. Okay.
Okay.
All right.